In today's show, we're going to talk about the difference between normal wear and tear and tenant damage and why you should care about it. Let's get into it. All right, welcome to another episode of The Accidental Landlord. I'm your host, Peter McKenzie. And today we have with us special guest, Rincon Property Management's Director of Operations, Stephen Kenney. Stephen, welcome to the show.
Hi, Peter. Thanks for having me. Appreciate it.
Yeah, we're excited to have you. For people who don't know who you are, why don't you give us a quick bio?
Yeah, sure. So I'm the Director of Operations at Rincon Property Management. I've been in the property management world for about 14 years, kind of all in Ventura County. Joined Rincon about 4 years ago and was a property manager, then kind of grew into the Director of Operations role. But yeah, I love property management. It's kind of my specialty, and I like working at Rincon.
Yeah, perfect. Glad to have you on. The reason I wanted to bring you on today is because we've got a theme going on the last couple episodes about maintenance. And this is an area that I think a lot of people underestimate the cost of it, not just financially, but to the overall operations of the property, tenant happiness or unhappiness, those types of things. So today we're going to talk about a very specific topic, and that is the difference between normal wear and tear and damage. And this is probably one of the most contentious issues in property management. Nobody ever really feels like they win. You know, is it the owner? Is it the tenant? Is it the property management company? There's a lot of nuance to it, and there's not a lot of clear-cut guidelines in the laws, which causes problems for everybody. But I'm excited about all your years of experience, all the times you've ended up in small claims court talking about these issues, because these inevitably are litigated in small claims court, and they almost always involve security deposits. So I think for someone who is an accidental landlord who's managing their property on their own, or has a property with a management company, I guess a lot of the same things apply. This will be a beneficial episode that hopefully they can wrap their head around a couple key core concepts surrounding this that will keep them safe and have a better experience as a landlord. So to frame the problem, I don't know if the problem, there's this concept of what's normal wear and tear. So for example, let's consider a wood floor. So normal wear and tear would be considered some wear patterns, like you always walk down the same hallway, or you always, from the entrance to the house, there's some scratches, some wear, discoloration. That's typically minor scratches. That's typically considered normal wear and tear. And normal wear and tear is the responsibility of the owner, not the tenant. The flip side of that is if the tenant damaged, that's in this case, we're talking about the floor. If they took a saw and cut a big old, saw cut down the middle of the hallway, that's not normal wear and tear, that's damage. That would be something that the tenant's responsible for. Obviously, these are two extreme examples, but I'm trying to frame the concept in the listener's mind. So you want to weigh in a little more on those examples, or before we get into the nitty gritty?
Yeah, well, I can't say I've seen anyone saw cut the middle of some wood floor, but an example of that would be, dropping a pot on the wood floor. It's something that doesn't naturally occur. So it's something that is the fault of the tenant, which in this case, it would be something damaging the wood floor. Now, normal pattern, like you say, it's definitely a pretty common thing. I would say the biggest misconception, though, is that landlords expect the property to be returned in the exact same condition that they got it. That's by far the biggest misconception, because you do have the wear and tear threshold that you kind of live with. So that's kind of where I would start with this, is what you can expect as a landlord kind of during a tenancy, stuff like that.
Yeah, I like to think of it this way. So if the landlord or the owner of the property lived in their property for 10 years, is that property going to look identical to when the day they moved in, say if it was a brand new house? And the answer to that is inevitably no. It's going to look like it's 10 years old. And the only way to make it not look like 10 years old is paint the walls, replace an appliance, replace some light fixtures, the typical things that a homeowner would do to spruce up the property or remodel it in some way, shape, or form. So the same principle applies. If you have a tenant or tenants, multiple, in there for a period of 10 years, it's unrealistic to think that the property is going to look identical from when you moved out to 10 years later. And that is the crux of the area that's not understood completely out there by a lot of the parties that are involved, because it's not going to be the same. It's going to need things to be replaced. And typically speaking, on the wear and tear side, that is not the tenant's fault, not the tenant's responsibility. It falls on the owner. And where all the disagreements come is, what's the difference between wear and tear and damage? And a lot of the times the owner of the property think that it's more damage and the tenants think it's more wear and tear. And inevitably, we have the pleasure of being in the middle of that and having to arbitrate those disagreements, which is a fun thing to do. Why don't we talk about that a little bit? Like, first off, how common is it where the owner's opinion of wear and tear and the tenant's opinion are two different things in your experience?
It's the most common thing that I deal with on a regular basis is the owners are expecting something, because what we do is we perform usually a move-out inspection, and we break it down as security deposit deduction versus normal wear and tear. And is probably 80% of the landlords will tell you that isn't this damage compared to normal wear and tear, and it's something like painting or like holes in the wall, stuff like that. And there's fine parameters that are in place by the state, by the government, in terms of what we can charge and what we can't charge. So that's a lot of times those awkward conversations with owners is, no, this is actually normal wear and tear, and it's based on kind of the principles that are in the law. So that's where I would start with that, but it's the most common thing, I guess I would say. So.
Yeah, so the problem is there is no clear-cut law, right? Like, there's this principle called, a piece of property has a useful life. So, for example, carpet has a useful life, meaning what is the carpet useful life? And the problem is it's not clear cut. There is no piece in the law that says this is how this will be done. There's all these guidelines and suggestions, and ultimately it's up to the judge to who's hearing you that day to make a decision. But if you try to be safe, you try to do the right thing, which is the way we run our company. We try to be fair to everyone. So like a carpet, what are we like? We're saying those are like roughly 6 to 7 years.
Yeah,
is that?
Yeah, 6 or 7 years is pretty typical for carpet. Oftentimes you get into the struggle with the landlord is, I've had my carpet 20 years and it still looks brand new. And it's the same premise that the guideline is 6 to 7 years for a rental grade carpet. And that's just the nature of the beast. So.
Yeah, so you get in front of a judge, or even before you get in front of a judge, and this is our job as a management company, is to say, hey, Mr. Owner, the carpet's 10 years old. It needs to be replaced because its useful life is expired. There might be a stain in it that the tenants put there, but it doesn't necessarily matter, because the judge is going to go, okay, what's the useful life of this carpet? Let's just say 7 years. Okay, how old is the carpet? Judge, the carpet's 10 years old. Okay, it's past its useful life. We're not holding the tenant accountable for anything regarding the carpet. And that's just the way it works. And typically in California, the judges are pretty pro-tenant. So even if there was like this gray area where it might be in the middle, like maybe we have a really good case, maybe we have some photo documentation, they typically will, if there's ever an opportunity, they'll side in favor of the tenant. So the reality is, I don't want to say it doesn't matter, because it does matter, but in the end, if you're standing in front of a judge, the only thing that matters is that judge's opinion, and they're notoriously pro-tenant. So that just brings up the question, well, what can you do? Like, if you're trying to hold your tenants accountable and make them pay for any damages, what's the best way to do that? And what's your opinion on that? Because I know you've been to small claims court many times, and like I said, you have dealt with this issue over and over again.
Yeah, well, the first thing you do if you want to hold your tenants accountable is make your leases as bulletproof as possible. Put some addendums in there, put some wording in there to help you kind of get it returned to as close to the shape you gave it to them in as possible. But ultimately, you're going to, if it goes down the small claims court route, you can almost be guaranteed that you're going to split it 50-50 at best. So you have to decide as a landlord, and what we do at the property management company is we advise the landlords, like, is this worth your time over this? Like, we are following the guidelines and your tenants aren't happy with that resolution. We presented them with the security deposit in 21 days. We gave it to them, and then they come back to us and want to dispute it. Now, a lot of times a security deposit is only 1 month's rent. So we're not talking an astronomically high amount of money. We're talking 1 month's rent, which when you start to break things down in the repair costs, and if we charge them for carpet cleaning and the carpet needed to be replaced kind of thing, that all that stuff is all negotiable, and we try our best to advocate for the owner and reach a settlement that we think's fair without going to court. Because at court, nobody wins 100% of the time unless you as the landlord completely didn't go by the book or did something really wrong in your process. But that's kind of how we tackle it. I think a lot of important things to talk about is move-in documentation at the beginning, to just make sure that you have documentation of what the property looked like, and then giving the tenants an opportunity at a pre-move-out inspection. I think pre-move-out inspections are really important. They often get overlooked because you just send a piece of paper out asking the tenant if they want that. But that's your opportunity as the landlord to go in there and say, I'm going to charge you for these things based on what's normal wear and tear versus damage, based on what I can see. So that's really your first opportunity as a landlord to walk in and say, this is going to happen, and give the tenants the opportunity to fix it outside of you charging them. So that's what I think pre-move out is super important. And then at the move out, you always want to take as many pictures as you can, especially of the damage, especially of the things that you're trying to find, because when you're going to small claims court, you need to provide all those pictures, the move-in pictures, the move-out pictures, everything to the judge and to the tenant to show them this is exactly why we're charging you. And that's the best way you can really kind of protect yourself as a landlord.
You led me right into my next question, and it was going to be this. What happens if a landlord shows up at small claim? Let's just say the carpet's the culprit, the issue that they're fighting over. The landlord shows up with 100 pictures of carpet and a 15-minute video that they took of the carpet before and after the tenant moved out. And they show up to small claims court and they want to go over every single one of these photos with the judge and talk to them about it. How does that play out?
Yeah, so first thing you have to understand about small claims court is most of the time this isn't a permanent judge. It's somebody that's sitting in, it's an attorney that's learning how to do the job and kind of filling in these spots. So they don't have a lot of time. They're trying to run through these small claim cases as quickly as possible. So I've had it happen firsthand. I took 450 pictures and I printed them out on 8x11 paper and walked in there with a big stack of papers. The judge looked at 4 of them and said, yeah, I don't know, it looks like there's damage here, Mr. Tenant. Do you have pictures to prove it? And then the tenant gave him a couple pictures and they were like, oh, it looks like it was that way when they moved in, so we're just going to split this thing. It's a quick process. It's a 10 to 15 minute case usually. And they encourage you. So at least in our county, they don't force you by any means, but they encourage you to go into a little mediation room and discuss how you can solve the case before even getting in front of the judge. So you're going to go sit there from 8 to 12 or 8 to 1 and basically just wait your turn. And in the meantime, they're going to be trying to get you to go in that room the whole time to mediate, which you could do ahead of time. So
yeah, which I will say, you didn't do that at Rincon. This was probably before you came here, because we don't show up to a small claims court with 400 photos because it's a complete waste of time, right? So the reality is, in my mind anyway, the ones I've been involved with, the judge is there to force you to compromise. And like you said before, nobody wins. They literally, most of the time, they'll split it unless one party is obviously being unreasonable, then maybe they might weigh a little bit in the other party's favor. But I've never really seen them just go, yep, 100%, this is landlord wins, tenant you lose. It's almost always, let's split the difference. And if you guys would have just done what we asked you to do, which was go in the mediation room and figure this out, then you wouldn't be here and you wouldn't be wasting our time. It's in no way, shape, or form like a court case you see on television where you got witnesses and cross-examinations. It's literally you have a couple of minutes to spit out your best case. Tenant has the same on their side. Judge may ask a question or two, and then he makes a decision and they kick you out. Like, it's literally over in a flash, which is why after doing this for as long as we've been doing this, the best case scenario is to negotiate with your tenant before you ever get to court, because there is a cost of going to court. You literally are dragged down there for half a day. A lot of times they get continued or they get stuck on one case. They don't get to your case. Schedule it out another 6 weeks. I mean, I've been involved in these where they've been continued for over a year, which is insane. It's a lot of time, a lot of mental anguish that you have to worry about how this is all going to go out. The best thing to do is just negotiate a settlement up front, because there is no clear-cut law and the judges don't really care. Like I said, they're not on the landlord side, that's for sure. So I think that's a pretty good representation of what happens in small claims court. Let's get down to some like actual examples so people can kind of conceptualize this in their minds. We have a document that we reference at Rincon. I have it here up on my email. We share this with both our landlords and our tenants, so everybody's on the same page. They know what we're considering wear and tear versus damages. And let's just talk about some of them. So when it comes to paint, yeah, so in this document, are you looking at the same? I think you have the same document in front of you, Stephen.
Similar one at least, so yeah.
Yeah, so faded paint, is that wear and tear or is that damage?
That's wear and tear.
Yeah, so and the chances of you ever touching up paint that's faded, what does that look like?
You'll talk to the most professional painters and they'll tell you, they'll guarantee maybe a 90% match for touch-up painting. You're gonna get the sheen just a little off. You're gonna get the color just a little off. The elements change the paint in the house, and then you can't ever match it. So we don't hold tenants responsible for like mismatched touch-up painting. As long as it's not like walls that they painted the wrong color, then it's usually better that they touched them up and patched them than leaving the big holes in the wall. So
yeah. Let's see. What about drywall? So is a hole in the drywall damage or normal wear and tear?
Depends on the size of the hole. So little finishing nails are considered normal wear and tear. They're stuff that you would hang like little pictures with. But if you're mounting your TV on the wall, if you're kind of putting floating shelves, stuff like that, kind of making the house into a home, then it's considered damage and it's a tenant responsibility. So
yeah, I think on our document it's holes in walls, doors, screens, or windows for misuse, negligence, carelessness, accidents, or abuse. And then on the other side, what we consider normal wear and tear is drywall cracking from settling, or like you said, those small finish nails. Let's see.
Just one thing with that real quick is you have to remember as a landlord that there's a useful life for everything. There's depreciation for everything. So like in our case, paint only lasts 4 years. So you have a small window anyways that you can charge a tenant for. And if you're trying to have a long-term tenant, then you're probably under the realization that you're going to have to paint after each tenancy.
Yeah, here's a good one. Smoke detectors or CO detectors. So what if tenant moves out, we do an inspection, and we find that the smoke detector is not working, but it's there? We consider that normal wear and tear. It's not the tenant's fault that the smoke detector stopped working. But if the smoke detector is missing or they took a hammer to it and it's in 1,000 pieces, then that would be considered damage. Here's the other one that's always a big fight are drains. So if there's a drain that's just draining slowly versus a drain that's clogged with hair, toys, or other things that shouldn't be in drains, slow drain, kind of arguably normal wear and tear. Drains that are clogged by, little Jimmy's Hot Wheels car, that's obviously damage. So this
is one that kind of gets brought up pretty frequently, and The one part I would recommend with this is whoever you hire to snake the drain, whether it's a plumber, a handyman, something like that, it really crucial that they put the cause of clog on the bill. That just helps you go a long way in determining what it is. Because plumbers are really good at telling you it's pipe buildup. Like, this drain is slow because of pipe buildup. It's nothing the tenant did, maybe soap scum, stuff like that. But then you have the cause of clog, which number one cause of clog is hair. And that's a tenant charge at that point, because it's a security deposit deduction because it's caused by the tenant and it's at no fault to the plumbing system. So that's a big one that I see.
Here's the other one that drives me crazy that I've seen before: hard water deposits. So we live in Ventura County, in Ventura anyway, specifically. The water is extremely hard, meaning there's lots of minerals and calcium in there. And if you're not careful, it will put hard water deposits on all your fixtures, on the shower doors, all of this. That is not the tenant's fault. So unless there's a water softener maybe that they turned off or they didn't use, possibly, but hard water deposits, normal wear and tear, because it's almost impossible to prevent. I mean, you'd literally have to be cleaning every time you turned the water on in order to prevent it. But that's always one that's interesting. Anyhow, I don't want to spend the whole time talking about wear and tear versus damages, but the point is, everything has a useful life. If it exceeds the useful life, it's really hard to charge a tenant for it unless, it's removed or they took a hammer to it. The big picture here, though, without getting just zoned in on just a security deposit deduction, is how am I trying to say this? If you zoom out and look at the big picture, what happened really well in your financial life by being a landlord compared to maybe something that didn't go your way? And what I mean by this is, if you have your house rented out for, let's say you have our average tenant stays 3.5, 4 years. This is called 4 years. And for 4 years, your property appreciated. I think average overall time appreciation is like 6 or 7%. But obviously in the last 4 or 5 years here, we've had ridiculous 20%, crazy numbers. Don't hold me to the exact numbers. Appreciation, let's just say it appreciated, 10%, and our average house is $700,000. So $70,000 times 4, let's call it $250,000 for the last 4 years, your house went up in value. And then you had your principal that was paid down by the tenant, presumably by paying the rent, which allowed you to pay the mortgage. Say another $5,000 or $6,000 in principal pay down. Then add on to that the tax break you got from having the rental property, which is different for everybody, but you can call that another $5,000. These are all really good things for your net worth as the owner of the property. You're talking about hundreds of thousands of dollars that you were in a better spot because you held onto that property and you rented it out. Now, did you potentially have to cover something that you thought might have been tenant damage, but ultimately wasn't? Maybe it cost you $200 that you think the tenant should have been responsible for? Maybe, but if you look at the big picture, it doesn't even compare. Even if you had to give the whole deposit back to the tenant and it costs you double that, if you compare it to the big picture, you're still better off keeping the property as a rental and experiencing all the things that I just outlined. I think that's more important. And when a landlord gets hung up on pennies or nickels over here that they're fighting with the tenant over, that generally doesn't end well. Like, your own mental sanity is more important than some change over on the side that you're fighting with your tenants, because everybody loses in the fight. Nobody walks away feeling good. It's just negative all the way around. What do you think about all that, Stephen?
Yeah, I mean, when you put it that way, it doesn't even compare. I mean, if you look at an average security deposit in our county, we're probably in the low 3,000s for security deposit. Like, you're talking over here making $300,000, or at least increasing your net worth by that much, and then you're going to small claims court. You're wasting a whole morning to fight over. Even if you had to give the whole thing back, like $3,500, it just doesn't add up in the scheme of things. So, not that I'm advocating to give the tenants all their money back, but I would just caution you to follow the normal wear and tear versus damages guideline and kind of make your best decision from there, but with the realization that you're coming out ahead as the landlord.
Yeah, I completely agree. And the other part of this that is helpful is when a landlord budgets for replacing things. So we obviously do an annual financial review for our clients, and we tell them, hey, your water heater's 15 years old. This is not going to last much longer. You should start saving for the eventual replacement of it. So if a landlord budgets for the replacement of things that everybody knows how long things last typically, like we're not seeing water heaters last 30 years, especially with our hard water, it makes it more palatable. So if the landlord can exercise some financial discipline and prepare for some of the things that they know are coming with our help of, being their eyes and ears at the properties, it makes their life a lot easier, because they're not all of a sudden staring at replacing a heater or replacing a water heater, or, the roof need to be replaced, and not being prepared for it, which is, the other end of this. So anyhow, I think that makes a lot of sense. Anything else we missed that you want to talk about regarding maintenance and security deposits and things like that?
No, I guess the last thing I'll leave here is, if you want to limit the amount of risk for the security deposit, I would encourage, and we encourage our clients to do repairs when tenants are in there. So do the repairs when they come up, or even do a little proactive maintenance on the property. What that does is it does two things. First, it lets you look at the property, or have a vendor look at the property to make sure that it's in good condition, and you could catch any kind of tenant issues or damage ahead of when they move out, where you can address it with them at that time. And then the other thing it does is it keeps your property looking nicer, which it helps you maintain it and overall kind of keep the damage limited, I guess I would say. So that's the only other thing.
Yeah, I would say that the other benefit to addressing things as they come up, one, it's good practice to keep your tenants happy so they stay longer, pay the rent, and take care of your property. But you also are limiting the potential financial hit you're going to take when they move out. So if you don't do anything to the property ever, and you tell all the tenants, no, we're not fixing this, we're not fixing that, which is a terrible idea. We definitely don't advocate for that. But if that's the way you were going to manage it, you're just asking for a big bill when they move out, because there's all this deferred maintenance. It's going to be more expensive, in my opinion. So by staying on top of the maintenance as the tenants live there, and replacing things when they need to be replaced, or repairing them when they need to be repaired, you're actually, in my mind, saving money in the long run, because you're not going to get hit with that $15,000, $20,000 turnover if you ignored everything for 5-10 years.
Yeah, exactly.
Stephen, thank you very much for coming on. Appreciate all the work you do for Rincon, and it was definitely insightful seeing your perspective on this. Hopefully it was helpful for our listeners. And yeah, till next time.
Thanks for having me.
All right. I know this wasn't the most exciting episode, but I want to thank you for your time taking to listen to this. This will keep a lot of people out of trouble when it comes to security deposits, what to charge, how to charge. You don't want to end up in a small claims court. But just a quick recap: know the difference between normal wear and tear and damage. Negotiate a settlement with your tenants if you do end up in a dispute. It's almost always better than what's going to happen to you in small claims court. And stay on top of repairing things. It's going to limit your losses and your expenses at turnover. Hope this was helpful. If it was, and you know some other fellow landlords, please share the episode. We're trying to bring more awareness to the podcast. Leave a review. Send it to your friends. It would be much appreciated. As always, thanks for your time. We value the time you invest in listening to the show. Until next time.